Hello, friends. You're listening to Exit Point, a podcast about the advancement of base jumping and an exploration of its culture. I'm Laurent Fratt, producer and co-host. If you've been enjoying our content, please hit pause, open the Spotify app, and give us a review. Also, this production is completely self-funded, so if you'd like to contribute, you can visit our Buy Me a Coffee link in the description. In this episode, I'm joined by Kendrick Dane, a licensed attorney and base jumper. We explore the evolving world of base jumping, its legal battles, community spirit, and the pursuit of freedom through human flight. Kendrick is also General Counsel for the advocacy group Base Access, whose mission is to preserve and open site access on public lands within the United States. We discuss the challenges and hopes of legalizing base jumping in national parks, his own journey through law and adventure sports, and the pivotal role of community and respect in advancing the sport's future. This episode is a dense discussion about the intersection of law, advocacy for our sport, and the culture war the National Park Service has waged against base jumping. Please welcome Kendrick Dane.
So what is base access?
So Brendan Weinstein started Base Access, Inc. It's a Nevada corporation. I think it was a year or two ago. I just recently got involved, so I'm playing a little bit of catch up. But it's a 501c3 nonprofit organization modeled in the mold of Access Fund in the climbing world, right? So, and what Access Fund and Base Access do is lobbying and litigation initiatives to advance the interests of the sport and the community, right? To ensure that we have access to jumping sites, that we have the ear of legislators and policymakers, so that we're represented in relevant decision-making circles, and also can push back when we don't get our a fair shake at jumping, right?
Right.
I know it's grown to include support from a bunch of folks. You and Matt, of course, Dylan Avatar, my late friend Lane Coates, who if we're successful in our appeals process and the subsequent litigation, or however we get our access to Yosemite, I plan to dedicate my first legal national park jump to, and a bunch of others. I can't name the whole team, and the folks I'm missing here, it's not because I don't appreciate and admire them, but I'd encourage people to check out the website, baseaccess.org, and you can get a lot more information there.
Cool. I want to hear a lot more about Base Access, but the reason why I asked you to chat with me today was I'm really curious about legal questions surrounding base jumping and what seems to be a really backwards approach from our federal government around an activity. And I think you're probably the most qualified to talk about that than anyone I've come across. So maybe we could just start a little bit by who are you and what do you do?
Sure. So my name is Kendrick Dane. I have been a licensed attorney for 15 years now. I practice mostly in business circles, commercial transactions, mergers and acquisitions, real estate, everything in between. It's funny. I tell people, even though the area of law that I hate the most is family law, most of what we do ends up being business family law, business marriage, business divorce, and everything in between. So let's see, I got involved in skydiving back in 2014, became a tandem instructor in 2019. I started base jumping in 2016 when I did it the modern way. Now I went to the bridge and paid Miles Dasher to throw me off a few times and bought a rig from him. And I grew up in aviation, so I'm, that's
this
pretty
is your
much
world.
Me. Yeah.
And how did you start, or what was your path to getting involved with the law?
Getting arrested when I was 18, actually.
Wow.
I took quite a winding path to get here where I am today. I was always a lousy student. Wanted to give people trouble. I had a chip on my shoulder. I got kicked out of my military high school, and then tried to go to a public high school here in Albuquerque. That was back when, the student was allowed to fill out your parents' contact information, right? So I think I put like Domino's Pizza's phone number on there and didn't show up to class for an entire semester. I actually ended up getting my GED instead of actually graduating from high school. I went to University of Redlands in 2002, and failed out after one semester there. I wasn't really ready for it. And, with a lot of family patience and love and support, I wound up in Nashville studying audio engineering, actually. And my very first night there, I went for a jog in the middle of the night, just to stretch out after the car drive there. It was January, and it had just been an ice storm there, so it was pretty cold. And I was jogging back to my car, and in an area of Nashville where a lot of people park their supercars behind, some swanky club. And I started I stopped and I looked into the Maseratis and Ferraris and, looking around. I guess some bicycle cops observed me doing this and assumed that I was trying to steal them. So they followed me back to my 1986 Mazda 626, which I guess they must have assumed I was going to settle for that after I couldn't get into the Ferrari, and tapped on my window and had me at gunpoint, got me down on the street, had a knee in my back for an hour and a half while 20 of their buddies and more cop cars showed up and were laughing at me and stuff, and they do what a lot of American police officers do and are allowed to do, which is they lied to me. And I didn't know that as a naive 18-year-old kid. They said to me at some point when I was shivering on the ground, "Hey, listen, man, if you'll just fess up to the fact that you're trying to steal those cars back there, we'll let you go." And so I said, "Fuck, all right, yeah, no, you got me. You got the great failure of a Lamborghini thief." And so they arrested me, and I sat in jail for a week before I called my family about it. I was so ashamed. And so this is getting to be a long story, but when I finally called my folks, they bailed me out, and they hired an attorney named Roger May. I'll never forget this guy, tall, handsome, silver-haired, met me in the courthouse wearing a camel hair duster jacket and just looking like $1 million. He shook my hand and smiled, and he said, "Well, we got to get you out of this here, son." And I said, "Yes, sir." He said, "All right, well, I'm going to go through that door there and talk to the prosecutor and see what we can do." I said, "All right." I didn't think much of it, right? This must be the beginning of a long process. Well, Roger came back 10 minutes later, after spitballing with his prosecutor buddy, I assume. And he said, "All right, that's it. You're off. All you have to do is not get in trouble for another year." And I was up for, felonies, several felonies. And I was blown away by the power that man had to help me in, my darkest hour, and do it, make it look so easy, and not for nothing. I mean, he got like $3,000 for that 10-minute meeting, right? So I thought, well, this is really cool, and I don't know how to balance my checkbook or what a covalent bond is. So let's do this.
Wow. Okay. Whoa, that's quite an introduction to the law and what inspired you. I'm wondering what inspired you to get into base jumping.
Well, sure. Like I said, I grew up in an aviation family.
Sure, but there's plenty of
stepdad.
aviation families that just do not look well on base jumping.
Well, of course. I mean, if skydiving is the redheaded stepchild of aviation, then base jumping is like the, institutionalized uncle, right? And I actually found skydiving and therefore base through the law. My folks are entrepreneurs, and they had an attorney who was a skydiver for many years. And as I was starting my career, he was exiting his. He was actually an extra in the movie Red Dawn.
Oh,
Did you ever see that?
Of course. That was on repeat at my house.
Absolutely, right? If you grew up in our generation, he was one of the Russian soldiers who parachuted in under rounds in the first scene and started, like machine gunning kids.
That's
awesome. But it was 2014, and at the time I was doing a lot of big wall climbing, ice climbing, and other sort of backcountry pursuits. I was involved in the mountain rescue community, but I was starting to get some pretty bad finger injuries and sort of phase out. And so Larry Reeser, the family attorney, brought me a case against our local skydiving drop zone. A gal during her FJC, jump number 1, broken her neck, sued the drop zone. It was everybody's fault but her own, right? And I went and met with them, and I didn't understand anything they were talking about, right? This parachute term, that parachute term, we all love acronyms and all that crap. And they said, well, why don't you take the FJC? I said, you mean the one where she broke her neck? Like, I don't think so, man. Like, I'm good. And then, I was laying in bed that night and I felt like a pussy, and so I went and did it, and it got its hooks in me. And then I started, you go from there and you're like, well, what's the next thing? And, at that time, the wingsuit proximity videos were all over YouTube, right? And I was watching stuff like Matt's Alaska Wingsuit Project and Dean Potter's Jumping in the Valley, and all these guys, Jeb Corliss, and going, holy shit, I got to do that. Like, that has got to be the purest expression of flight, right? Like the achievement of man's oldest dream. So that's what led me there.
Now, you come from a multi-skilled, multi-sport background, and you brought up climbing and ice climbing. And do you, from a personal perspective, see base jumping as wildly different than any of the high-risk activity that you've been involved in?
Absolutely not. And I think that there's empirical evidence that backs that up. If you want to go climb K2, there's a reasonable chance that you're going to die in an ice fall, or you want to backcountry ski. Even the most learned folks who go and get their avalanche training and carry all the gear and know how to be there for their friends, die all the time, just about anywhere that activity's done. I've watched several people deck at the crag, or break a leg falling up, halfway up a grade 4 big wall. You know what I mean? And it's really no different. I mean, we're para-alpinists, right? And alpinism is a natural part of that. For most wingsuiters, I think, at least, if you want to fly the big air, you got to get to the exit point in the first place, which is its own hugely technical thing sometimes, right?
Absolutely. It's interesting too now that you say para-alpinism, and the word is, or the name is growing and growing. Like Chamonix Valley has exploded with these single skin parachute or paragliders, and now there isn't a day that goes by that you don't see somebody landing in the paragliding landing area with, their full alpine kit, and it's really transformed, day missions, because you don't have to walk down anymore. And
yeah, and that's the worst part of the hike, right?
Absolutely. Absolutely. Especially with my old knees.
Yeah. Chamonix is an interesting place. I went there first in 2018, and I was late I missed my flight home for my first, Brento trip, and didn't have time to stick around. But my wife is a fluent French speaker and had never left the country, and she wasn't my wife until this summer. So I took her. I said, let's go to Chamonix and let's get married on the Aiguille du Midi. And she said, don't threaten me with a good time. And you guys have faced some stuff in the Chamonix Valley similar to what we are dealing with MPS, right? I mean, I think it was 2016 or 17 you lost legal access to the Aiguille du Midi jump.
Yeah, that's right.
Yeah.
And so the Brevant and the Aiguille du Midi, just for an update on that situation, are closed, what looks like to be permanently. And all of the high alpine jumps, meaning the ones that require some hiking or walking or climbing to get to, are open. So what they've really tried to do is limit the volume of jumping and the ease of access to those two exit points. But it was quite a process.
That's a shame too, right? I mean, those are some of the crown jewels.
Absolutely. It is a shame. And, some of the locals feel optimism around it. And there is one sort of, topographical or geographical issue is that, people are going to be opening parachutes over the town. And there needs to be some sort of control mechanism in place to keep people opening their parachutes out of town. But before that can happen, there will be some small steps, opening it, opening those high alpine jumps now is more or less a test piece, and just to see how it goes will be, under the scrutiny of the local government. But it's funny because in France, it's an activity. It's not a sport because it doesn't fall under a federation, and it's not a competitive endeavor. And so it's more or less free, based not, there's some limitations if you're in a ecologically sensitive zone or this, you're threatening the habitat of the birds or whatever. But in general, it's legal. And this was one of the primary reasons why I left the United States was to pursue my passion. And it's just so backwards that, we consider the United States as the land of the free. And we have this blanket law that doesn't make much sense to me. And maybe you can help fill in some gaps here. Like, where are we with the law and the legal issues surrounding base jumping right now in the United States?
Well, I mean, it depends on your locality, right? America is a republic, so each of its individual 50 states and its territories has its own mini government with an executive branch, a judicial branch, and a legislative branch, and they're all free to sort of carve their own path, right? In most instances, if you're not in a national park or U.S. Forest Service managed areas, earth jumping is pretty accessible, right? BLM in particular, and places like Moab are very permissive, although you see access in places like Moab curtailing too, for the same reasons it was curtailed in national park units and forest units because of overuse, people leaving behind waste, bolting rocks that they shouldn't bolt, so on and so forth, right? It's always a stewardship and overuse issue. But for the large part, outside of those areas, you're looking at, if you're going to go jump a building or an antenna or, most bridges, with, one notable exception, maybe two if you count Bridge Day, you're talking about simple trespass, right? Most places a lower class misdemeanor. It's a fine, almost never a jail sentence associated with that, although theoretically possible. Then if you're in the building world, it gets a little bit spicier. You're talking about access tools, which means willfully breaking and entering barriers that were put up specifically to keep you out. So that can elevate it to a felony. And then in the National Park Service, you have two rules: the aerial delivery rule at 36 CFR 2.17 A3, and you've also got the powerless flight regulation, which they don't really use anymore. I have a little bit more on that later, but those are basically what you're looking at, and those are both prohibitions that come with criminal sanctions. So you're talking about a maximum of 30 days in jail, a $5,000 fine, and civil forfeiture of all the gear you use to do your jump, right? So not insubstantial, and they do prosecute them to the absolute fullest extent.
Do you think, from your legal background, that the punishment is fitting for the crime?
Well, I mean, no, of course not, right? The law, and like the first day of law school, they sort of have you start thinking about our collective body of laws in two different categories, right? There's your, and it's all Latin, right? They, on the one hand, you have malum imse crimes, right? Crimes of moral turpitude. These are like your 10 commandments, your lying, cheating, stealing, and murdering, right? Things that are just morally wrong. And by and large, the vast majority of everything else that we've chosen to make a rule about is just a malum prohibitum rule. Some policymaker or body of policymakers has decided, for a good reason, a bad reason, or no reason at all, that something needs to be banned. And those are, I guess, easier to resent, right? Particularly if it impacts you in a disparate way than proportionate to the rest of the public, and particularly if it wasn't even intended to impact you that way, right? Because it was made before parachutes ever were created or the sport of base ever came to be, so on and so forth.
You talked about aerial delivery. Is that a law that came into place before parachutes or before base jumping, and it was sort of slapped on for an all-use sort of? Excuse me, I don't have the vocabulary to explain it in law, obviously. So for me, it sounds, and this is mostly rumor and hearsay, but what is this aerial delivery law, and how are they using that? So National Park Service promulgated the aerial delivery rule in 1983. Promulgated meaning? What is promulgated?
They published, they established it, right?
Okay.
And the conspiracy-minded will note that the timing of the publishing of that rule, 1983, follows closely after Yosemite briefly flirted with, the first people to ever make base jumps, right? In 1978. Well, I guess you had two guys who made round parachute jumps in 1966, but no cameras are around and they weren't punished. Both of them got blown into the nose and broke both their ankles, and I think the Rangers probably just figured that was enough for their just desserts and sent them away unharassed, right? So others point out, however, that whenever a national park is created, it involves a massive transfer of land from usually a patchwork of state and local parcels, right, to the federal government, right? And whenever that has happened historically, there always remain a couple of little landlocked patches of land inside of those newly established park units that weren't owned by the state or local government. They were owned by private parties, and they weren't keen to give it up. So, Americans being, fiercely libertarian the way they are, they'd say, you can get it out of my cold, dead hands. Some of those were in the middle of Yosemite Valley, right? So what the National Park Service did to those folks, as a matter of policy, was to make life so hard for those landowners that they were forced to sell their little plots in the parks to the federal government. Park Service accomplished this by banning the owners from accessing the properties, right? Say, okay, you want to get cheeky, you want your property, how are you going to get to it? How are you going to get provisions in there, right? You can't use our roads around it. That's our stuff now. So if you've got a landlocked acre in the middle of what's suddenly become a park and the feds now own the surrounding land and want to push you out, how do you access it? Well, certain enterprising landowners took to helicoptering and parachuting themselves and their supplies to their parcels to get around these government takings. And this is the primary reason that the aerial delivery rule was published. I mean, you can sort of sense it from the text of the rule. And that text is, sorry, I'm pulling up my notes here.
Yeah, please do.
Delivering or retrieving a person or object by parachute, helicopter, or other airborne means, except in emergencies involving public safety or serious property loss, or pursuant to the terms and conditions of a permit, is prohibited.
Huh. So this sort of opens the question about the permitting process, because this is potentially a way forward in equal use of the park. Where are we with the permit process?
So last year, Base Access submitted applications for special use permits to Yosemite, Grand Tetons, Glacier, Zion, Grand Canyon, Big Bend, Kings Canyon, Guadalupe, and the Northern Cascades. Pretty much anywhere where there was a compelling wingsuit jump. The National Park Service has never in all of its history since Base first arose, with the exception of 5 weeks in the autumn of 1980 that we'll talk about here maybe in a little bit. They've never given a base permit to anyone, right? So far, Yosemite, Zion, Grand Teton, Grand Canyon, Northern Cascades, and Guadalupe have rejected Base Access's permit applications. And frankly, the rest of them are going to do that in the ordinary course at some point, right? National parks.
About the ordinary process, are there other activities that are requesting special use permits that are being granted?
Oh, yes. You can get a permit for just about anything. You can get a permit to climb. You can get a permit to film a movie for enough money, right? Even maybe one that features an active base jumping stunt conducted within the park. You can, you can get a permit to kayak. Interestingly enough, and sorry, I'm looking through my notes here. You can rip up a golf course. You can get a permit to hold a political rally or a protest. You can get a permit for hang gliding, and you can even use personal watercraft, with an onboard engine, which, interestingly enough, has a regulation almost identically worded to the aerial delivery prohibition regulation. And it has a criminal sanction just like ours, but the NPS likes boaters, so they do give them permits notwithstanding the prohibition. And 15 of the park units have even made special regulations that exempt personal watercraft from the general, system-wide prohibition on those boats, right?
Right.
About the only thing you can't get a permit for besides base is paragliding. And that's interesting because, people have been talking for 50 years about, well, wait a minute, hang gliding has been allowed in Yosemite National Park, and I think others, but, let's focus on Yosemite here. since the earliest days of the park. And when they, matter of fact, when they published the aerial delivery final rule in 1983, the National Park Service noted that all of the public comments they received, or substantially all of them, were opposed to allowing hang gliding. And the park said in its final rule, in its commentary, well, we're going to apply this fairly to everyone. And obviously they haven't. They allow hang gliding because some of the rangers were hang gliders, right? So it goes to show you that, if the park wants it done, or likes your category of user, you're going to get what you want. But they won't allow you to use a paraglider, even though it's identical in all substantive respects to flying a hang glider. It's a soaring device. You're riding thermals. It arguably has a lower environmental impact, right? You don't have to haul all this equipment and gear and this rigid frame wing. They just don't like it because to the uninitiated, it looks like a parachute, right? It's a ram air canopy, and they hate base jumpers, and they always have. That's how deep the animus goes. I mean, never mind that USHPA, U.S. Hang Gliding Paragliding Association, regulates both gliders, and they're the same thing. Looks like a parachute, you're out.
Yeah, that's interesting. Like the impact for sure, like, right behind my house, there's a paragliding launch. And when the hang gays come out, it's, this may be, it may be trivial, but, they do come out with a ton of gear, and they always have to drive up real close to the launch. They lay it out. And this is not to harp on them in any way, but the impact of the area for sure is higher from them than it is from the hang glider or the paragliders.
Yeah, nobody's hiking that monstrosity up to a 3,000 foot mountain exit point, right?
What is the American Procedures Act? Because I read about that, and it seems like there's some connection there with the permit process. Can you talk about that a little bit? Yeah,
sure. And in order to talk about it, and I think you're talking about the Administrative Procedures Act. The APA, but in order to really understand that statute, the question of the APA first requires an understanding of kind of how we got here historically and just the general legal framework and constitutional basics that, underpin American law, right? So if you'll bear with me,
please give us the background. That's great.
Yeah. So in the Constitution, the federal Constitution, Article 1 establishes the Congress. Congress is charged with the duty to make the laws, right? Article 2 of the Constitution establishes the executive branch, led by the president, charged with executing the laws that Congress has passed. And Article 3 establishes the federal court system. And since 1803, when the Supreme Court heard a case called Marbury versus Madison, the Supreme Court has said, with respect to what its role is in the constitutional order, its job is to decide what the law is, right? So these are our checks and balances and who does what, right? Well, NPS, National Park Service, obviously isn't Congress, right? They are not noted anywhere in Article 1. In fact, they're an executive agency of the executive branch, right? So how is an instrumentality of the president, who is only supposed to be executing the law, not making law, not only making law, but making the most serious law you can, those which have the potential to deprive you of your personal liberty, put you in jail, right? And this is part of our constitutional history. So Article 1, the grant of legislative authority to Congress, gave rise in the early republic to what's known as non-delegation doctrine, right? And this it actually goes back to the 1620s. Some credit it to John Locke, the English Enlightenment thinker. But it's a principle that prevents Congress from delegating or abdicating its legislative powers to other entities, right? The theory is that separation of powers principles says that one branch of government must not authorize another entity to exercise a power it's constitutionally supposed to exercise itself. And this prohibition typically involves Congress delegating its powers to administrative agencies or to private organizations. So this first appears in American jurisprudence in 1825 in a U.S. Supreme Court case called Wayman versus Southard. Now, in that case, Congress had delegated to the Article III courts, the federal courts, the power to publish their own rules of judicial procedure, right? Wayman versus Southard contended that Congress had thereby unconstitutionally clothed the judiciary with legislative powers, and we can't do that under non-delegation. Chief Justice John Marshall said that delegation was okay because the procedure rules are mere details of the law, which non-delegation doctrine allows by necessity, right? You've got to fill in the color of broad congressional mandates, right? The court said essentially, we agree, we hear you, but we're only going to enforce non-delegation when the delegate tries to make substantive law, not just fill in the color, right? And that principle held for as a powerful check on the expansion of government for much of the 19th and early 20th centuries. And it hasn't been used at all since a 1935 case, Schechter Poultry Corp. Versus United States, which is a case that considered a law that allowed the president to approve trade codes, which, the regulated businesses drafted themselves. And the court said, no, this is a bridge too far. We can't let businesses write trade laws, right? Their duty is to their shareholders. They're going to screw over their competitors. It's not good policy, and it's a violation of non-delegation. So times change, right? By 1935, we're in the middle of the New Deal revolution, when the Supreme Court, in a series of cases, reined in non-delegation. Some of those cases include Carter versus Carter Coal Company in 1936. I'm not going to name them all, but those cases curtailing the import that we gave to non-delegation doctrine paved the way for the rise of this, modern, ever-expanding administrative state that we have now. And this is obviously not a rigid timeline either. By 1936, for example, the National Park Service was created by a congressional act in 1916. The IRS was created in 1913. Before that, there was no federal income tax. And Congress created the IRS to collect the tax, knowing that, they couldn't pass a new law every time they needed to audit a person who didn't file their 1040 easy, right? So whatever your opinion on the subject of the administrative state, academically, we as a country just increasingly embraced that administrative system because of its pragmatic necessities, right? Which makes sense even if you disagree with the current state of it. And as I think probably we both do, right? Historically, Congress has a hard time getting anything done. There's many reasons for that I won't get into, and views differ on that. But one fundamental human reason is that it's hard to get 535 people to reach consensus on whether water is wet, right? Have you ever tried to organize a 100-way base jump, for example?
No, because I know the result.
Right. So Congress can't collect your taxes. They can't even pass a budget in the current Congress, which is the least productive in U.S. history. And frankly, they're always, charitably 10 years behind socially and economically seismic shifts in how society works, right? You would for example, not want them in charge of regulating the national airspace system as the FAA does. They lack the expertise and the urgency to respond to crashes or, emerging technological breakthroughs, so on and so forth. So I'm getting to your question now. Finally, what is the Administrative Procedures Act? It's a federal statute that Congress passed in 1946 in response to all of the concerns we've just talked about, right? Like, wait a minute, we've created a monster here. Executive agencies create the largest volume of new laws every year by far, and still do today. We need to somehow regulate this and put a procedure in place to make sure that what they do is not arbitrary and capricious and is instead rationally and fairly connected to a legitimate policy objective, right? So you can think of, even though it's a statute, you can think of the Administrative Procedures Act as somewhat of a constitution governing the way administrative agencies of the federal government propose and establish regulations. And it also grants, importantly, particularly for our cause, the U.S. courts oversight over all agency actions. Generally speaking, it forbids them from making rules or any decision really without basing it on an evidentiary record, supporting the reasons for the rules, making that rational connection between the proposed rule or decision's policy goal and the authority the agency has been given by Congress to make the rule or decision in the first place, and offering some kind of evidence that the rule will accomplish the goal, right? The shorthand phrase people often think of in connection with that statute is arbitrary and capricious action. That's what it forbids.
So with all that being said, how are we in a situation where a federal agency can create new criminal laws and absent from validation from Congress?
Well, a large part of that has to do with various doctrines established by the federal courts that seek to defer. When you have a statutory mandate or a regulatory mandate, and it's not quite clear what it means, the courts have decided in a series of cases over the years that because the agency has the subject matter expertise, we're going to defer to their interpretation of it, even if it's their own rule. I mean, they're probably wary of substituting the judgment of 9 lawyers in robes who failed high school biology for the judgment of EPA scientists, so on and so forth. The big seminal case that established that was Chevron USA Inc. versus Natural Resources Defense Council in 1984. Just quickly going through that, the court there was asked to second guess the EPA's interpretation of an undefined term in the 1977 Clean Air Act, which is and now we have an act of Congress. There's a dispute over what the meaning of the words stationary source mean with respect to like a pollutant emission, right? And that case had a huge impact in the ensuing 4 decades of cases that in any way challenge an administrative agency's exercise of its power or interpretation of Congress's edicts. And so the case established, Supreme Court in that case established Chevron deference doctrine, which basically means that faced with, a private litigant's interpretation of congressional text and the administrative agency's interpretation of that text, the agency with jurisdiction to exercise that congressional power, if that's the case, the court is not even going to question the agency's interpretation, so long as the agency's answer is not unreasonable and so long as Congress hasn't spoken directly to the precise issue at question, right?
So if there was actually a legal procedure around base jumping in a national park, the Chevron doctrine is something that you guys would be talking about?
Indirectly, right? So, like, astute listeners are probably saying, well, hold on a second. You said the National Park Service wrote this regulation, not Congress. And Chevron talks about an agency's interpretation of Congress's words, not its own. So we're good here, right? We can challenge it. Well, the federal courts are kind of lazy, and any time that they can kick something out their door or punt an issue down the road, leave it for someone else's mess to clean up, they often do. So Chevron doesn't directly itself apply. But in a subsequent 1996 case, Auer versus Robbins, the court essentially extended Chevron deference to an agency's interpretation of ambiguities in its own regulations. Thinking about what does that mean for us, right? Well, it has a big impact. There's a line of cases in the 90s and 2000s that examined the aerial delivery rule in connection with prosecution of base jumpers, right? Mm-hmm. In 2000, the Ninth Circuit Court of Appeals, based in California, heard United States versus Mark Albers. Are you familiar with that one?
I'm not.
So Mark was caught in Yosemite and prosecuted under 36 CFR 2.17A3, the aerial delivery rule. He was pretty clever and he had some resources, and he was convicted, and then he appealed his conviction to the Ninth Circuit. He said, hold on a second. I'm not using a parachute, quote unquote, as the regulation prohibits. I'm using a ram air canopy, which is a type of aircraft permitted on designated lands in the NPS. So this conviction is invalid. And the Ninth Circuit shot him down, applying the Auer deference doctrine. So, in other words, the reason we're facing this impunity is that the courts have allowed it as they've backed away from non-delegation doctrine and as they've created a bunch of deference doctrines. We now live in a system that allows the agency of unelected bureaucrats who wrote the rule and put a man in jail under the rule to say what the law is instead of the courts doing so themselves, which, I think is an affront to Marbury versus Madison. And John Marshall's probably rolling over in his grave right now.
Now, are there any limitations to sort of laws that the NPS can come up with to fit what they deem is correct?
I mean, they're constrained by Congress's grant of the delegated authority to an extent. But, the judiciary's wide deference places them in a position to stretch that grant of authority to the boundaries of plausibility, basically, right? To be defeated as an agency in the interpretation of your own rule, your explanation for why you made the rule in the first place has to strain credulity so far that it makes like a layperson judge who knows nothing about parachutes or EPA regulations jump out of their seat and ask, wait a minute, how does one follow from the other here? How does this accomplish any of the mandates that Congress set out for you? So, in the case of the National Park Service, they have dozens of congressional mandates. The Park Service was created under the Organics Act in 1916. They have additional authorities for rulemaking for sensitive ecological zones under the Wilderness Act of 1964. That's a congressional act that has generally been interpreted to prohibit mechanized transport in designated wilderness areas, right? It required all the parks and the USFS folks to determine what constitutes a wilderness area. These are huge, broad, vague grants of power, right? The NPS has they're also bound by executive orders, which are basically a president's unilateral policy proclamations that hold effect until they're repealed by a successor president, right? And gives them more reason to rule make. And because of deference doctrine, the agencies can even look to their own internal authorities, right? For reasons to make, and now we're compounding the issue. Well, Congress gave me this, so I made a rule about it, and because the courts are going to defer to me on it, I can look to that rule that I made as justification to make another rule that I made. As long as National Park Service can show a connection between the rule proposed and their mandate under the Organics Act to preserve the park for, and I'm quoting here from the statute, for the unimpaired for the enjoyment of future generations, end quote, then they can enact rules in furtherance of that, constrained only by, the APA, the Administrative Procedures Act, the APA sort of substitutes for due process, the equal protection guarantees of the 14th Amendment, Section 1. And that's about it.
So there, quite a few times you've mentioned that they just don't like base jumpers, right? I think you said it 3 times already so far. And, I'm just thinking, okay, so this is sort of like a culture versus culture battle. Now, when I think about that, I think, okay, well, eventually, then people will leave lose their tenure within the National Park Service, and there'll slowly be an evolution of culture within their department. Is that the case? I mean, do the Park Service personnel have a certain amount of tenure, or are they in that position for life? Or please inform me.
Right. So I don't know how long, like the average NPS employee serves. Generally speaking, in the, administrative agencies across the federal government employ several 100,000, perhaps even 1 million Americans, right? And they're, they do important work, and this is not, to denigrate what they do. But they're, from a benefits perspective, they're quite cushy, right? You can get perks in a federal job that you would never find in the private sector, including that after a 20-year term of full-time employment, you can retire with a pension equal to like 95% or something of your salary at the time you retired, right? So there's a strong incentive to stick around for 20 years, and you see that, right? There isn't the kind of job shuffling that you see in the private sector as people chase opportunities, in various different places. So they're not elected. This is just like applying for a job at Apple Inc. or a law firm or so on and so forth, and they have discretion to decide whether they're going to hire you or not. Each agency is a little bit different in terms of how their leaders are enter the job, right? It depends on what the Congress's enabling legislation mandated for that process. Typically, it's headed by a person appointed by the president, right? So those people do cycle in and out in, political cycles, right? New president comes in, cleans house, establishes people. Other agencies, like the Consumer Financial Protection Bureau, Congress tried to insulate that, the leadership of that agency from political interference, right? So they tried to, quite frankly, I'm sorry, I'm tired and I forget how they are appointed, but they don't serve at the will of the president, right?
You're doing great, by the way. This is going really well. Super interesting.
Thanks. I had to prepare a lot for this. One of the fun things about this job is that you learn something new every day, right? This is a little bit outside of my wheelhouse. We're not talking about a partnership dispute or, a real estate issue or what have you. So, but, it's a cause near and dear to our hearts. So did a lot of research.
It shows.
I make a shitty constitutional scholar, though, so no one's ever accused me of being a great constitutional historian before.
Are there any particular cases that we should talk about?
Well, So there is our own case that has not been filed yet.
So you are involved with the case already. Good. That was my next question.
Right. I got you. Yeah. So the reason Base Access filed all of these applications for special use permit, even though they knew with 100% certainty that they're going to lose their application fee and all of them are going to be, blanket denied, is because if you want to challenge an agency's decision, like the decision to prohibit and prosecute base jumpers within the parks, you have to first exhaust your remedies at the administrative level, right? So in other words, you need to submit the application that gets denied. The Administrative Procedures Act says then you have your first layer of appeal from there is also at the agency. So your appeal goes just back to the agency, not to a court, right? And you craft a document that collects the history of the facts that establish why the decision was wrong. And you articulate your argument, for example, the National Park Service's failure to timely act on or approve or deny a base jumper's permit constitutes the unreasonable denial or delay of agency action, contrary to Section 706 of the Administrative Procedures Act. And it's also constitutes a violation of the Equal Protection Clause, the 14th Amendment, Section 1, because, motivated solely by animus towards base jumpers. And we can talk about that history between jumpers and the parks if you want, because it's relevant and it's important for the future too. But, just because of this animus, NPS intentionally regulates us differently from similarly situated individuals engaging in identical activities, and there's no rational basis for that distinction or that disparate treatment, and so on and so forth. And, because you're going back to the agency that hates you in the first place, they're going to deny that, right? But that administrative appeal forms the basis for your federal court complaint. Once that appeal is denied, you can walk into the U.S. District Court for the Eastern District of California that has jurisdiction over, Yosemite Valley, the Yosemite Park Unit, and file a lawsuit asserting these various different articulations of APA violations and equal protection violations. And from there, what typically happens, the federal government will move to dismiss the case, and oftentimes dismissal is granted. So it's a heavy burden. If you can get it past that stage and start putting the squeeze on the administrative agency, you get access to their documents. You can take depositions, and get sworn testimony from their decision makers over there that establish your record. And then typically in these kinds of cases, they don't go to trial. They get resolved in sort of a paper trial process known as summary judgment. That's just a procedural mechanism where, both of the parties walk into court, after they've taken their testimony and gathered their documents, right? And they say to the judge, we agree on what the facts are, right? Here's the set of facts that we all agree on. We disagree on how the law applies to those facts, right? And in our judicial system, it is typically the judge's prerogative to decide what the law is, and it is a jury's prerogative, a fact finder's prerogative to resolve questions of disputed fact, right? So because those don't exist, the parties go in and say, Judge, you can decide this right now. We don't need to have a trial. Here's the facts. What does the law mean in light of these facts, right? And that's typically how these would get resolved. So the goal is, we're obviously not an entrenched, deep-pocketed interest group, right? With, billions of dollars in dark political money or, powerful business interests, things like that, right? Agencies typically respond to those groups, right? Because they have the resources to put that firepower downrange and really burden the national park system. So often, if you turn the heat up enough, you can at least force the administrative agency to negotiate, right? And it may or may not be successful, but that I view that sort of as our first opportunity to bridge this gap, right? You talked about, well, geez, this animosity, it's from that's based on the sins of a few committed over a half century ago before we were even born. Why are we still here, right? And of course, it's because the people who were policymakers then passed that culture down, and it sort of metastasized, and now it's difficult to change the culture of an agency that has 20,000 employees and 280,000 volunteers, right? But this is how we do it. Base jumpers have done themselves no favors, I think, with how they interact with the federal government. Is that fair to say?
Well, you would be in the right shoes to say that or not. I mean, I don't really know what the culture and the situation's like in the National Park Service or national parks in the United States right now. When everyone says, base jumpers are just going to ruin it, I don't know. I mean, I see the culture around base jumping evolving rapidly, and it's difficult to say.
Well, you make a good point there. It has evolved, and that's why we have this, for the first time in 2 generations, opportunity to demonstrate that this is no longer, a circus stunt for, the outlaw inclined, and, participated in by people who break the rules, right? We're notoriously ungovernable as a group, and that's one of my favorite things about the sport, right? But it is a problem here because, as happened, 44 years ago, will happen again if all of these efforts are for naught. If even one person breaks the rules and, is a shithead to a park ranger, jumps without a permit at a time of day when they're not supposed to do it, right? And that's antithetical to how we think, right? That just makes you want to break the rules even more. And I'm not passing any judgments on that. I mean, I have the same, mindset, right? Exactly one statute of limitations ago, I engaged in quite a bit of bandit jumping myself, right? But in the parks, we have to evolve in particular to be compliant and treat the NPS as partners if we get the opportunity to do this. Because one person will have it all taken away, and there might not be another opportunity ever, and certainly not for another 2 generations, right?
So, I mean, partnerships usually come about through open channels of communication. Is there any communication amongst or between the Park Service and the base jumping community?
There has been extensive communication between them. That is not what the National Park Service would tell you, but I find that kind of disingenuous. Matter of fact, I'm going to look at my draft of the appeal because we lay all this out in our facts, right? In 2004, Republican representative from Texas, Tancredo, wrote a strongly worded letter. He must have had a base jumper buddy. I'm not sure what the context is. Wrote a strongly worded letter to NPS director saying, this is not fair the way you've chosen to regulate this. I propose that you establish a permitting system similar to the way you do, hang gliding, so on and so forth. And NPS wrote him back and said, we welcome the opportunity to engage with this community. This has to go through a park planning process, which is, a legitimate mandate that they have to do, right? Various statutes since the 1970s say, if you want to do this or that, it's got to go through an environmental review. It's got to go through a planning process, bureaucratic processes, right? Matter of fact, I'm going to quote this. Let's see. In response to that Tancredo letter, P. Lynn Scarlett, MPS's Assistant Secretary for Policy Management and Budget, wrote, quote, Director Maynella is committed to providing the public with appropriate opportunities for enjoyment of park resources and values, and to thoughtfully reviewing our policies and procedures when they are called into question. I am confident that she would expect park superintendents and other NPS decision makers to give serious consideration to parachuting and similar activities as part of their normal responsibilities for managing recreational users, end quote. Well, and then she closed her correspondence with the entreaty that, NPS hopes that members of the parachuting community will avail themselves of the many opportunities that the parks offer for involving them in the planning and decision-making process. And not to put too fine of a point on it, Laurent, but it's bullshit. These planning processes happen periodically. One example that comes to mind is Zion's 2007 initiative. Let's see here. Yeah, so Zion amended its wilderness stewardship plan in 2007 and received over 50 comments asking the park to allow base jumping during the comment period on the draft plan and environmental assessment. And Zion admits they didn't even bother to include base jumping in its scoping process, right? And that's what they do. They throw our stuff in the trash, right? The only responses we ever get from them typically are these empty platitudes like, gee, just participate in the park planning project process, and at some point, we'd love to have you. And then when those come around, we're ignored, and the only other correspondence we get from them is denials of our permit applications. In fact, they've chosen not to even deny them because I think at least because then they could argue when we go to court that, hang on, this isn't a final agency decision, and you need to have a final agency decision to have an APA violation. But it is arbitrary and capricious to purposefully not act upon permits, right? They just say typically, and the typical response is, this needs to go through a planning process, and we don't have the resources to do one right now, so, good luck. Which I find baffling because, like we talked about earlier, when they want to get something done and they like the group of users that want it done, they just do it. Yosemite's conducted 831 planning processes, at least according to their online public comment system, right? So there's 50 years of outrage here. Base 38, Rick Harrison, the guy who runs U.S. Base Association, for those of you guys who got your base number and stuff, was general counsel for the Alliance of Backcountry Parachutists in the early 2000s, doing something similar to what we're doing today. And matter of fact, I think he might have some credit for the park trying to prosecute jumpers under the unpowered flight rule and moving instead to this parachute delivery rule. So he was a DOJ lawyer. He worked for the federal government, right? Imagine being a base jumper in that employ. You got the fox in the hen house. So in 1983, right around when aerial delivery came around, he and Phil Smith base jumped into the Pecos River, got busted by park staff. At least Phil Smith did. Rick went and represented him and got the case kicked out on a motion to dismiss, and that was the last time they tried to prosecute a base jumper under that. So that's just an interesting piece of history.
Are there any notable arrests or cases that come to mind when you think about this whole situation that are worth mentioning?
Sure. I mean, history's littered with them.
I mean, I think it just helps to paint this picture of like the absurdity of the situation, as there are cases where people have lost their life being chased by NPS and
right.
I
still do the Gambale pack job, that's what Miles taught me. And for those who don't know, I'm sorry, I'm getting a blank look. But Frank Gambale jumped off of the nose in, what was that, 96, something like that, and was pursued by Rangers. The Rangers have dedicated task forces that specifically charged with pursuing and arresting base jumpers that they catch, right? So one of them, Frank is, bundling his stuff up and he gets apprehended. He jumps into the Merced River, on the other side of El Cap Meadow. And it was April, and that meant the river was at, peak CFM, peak water flow from, the snow melt. And he was trapped under a rock and he drowned. They didn't find him for a couple days. This has real world consequences. Prohibiting something never makes it go away. We've seen that with, drugs, abortion, you pick an issue, right? But in 1977, the Yosemite Rangers actually, they were already fed up with Carl Banish and his ilk, right? They brought the circus show with them, the fangirls, they're making movies, and that really sparked the public imagination, really like furthered the growth of bass, right? It was the first time it was really kind of brought to the world, even though it was being done before that. And so by 79, the Rangers got fed up. They established the SPLAT team. This is the Stop Parachutists Leap at the Top is what that acronym stood for. One of the base jumpers who has an active prosecution against him right now, David Nunn, got that testimony out of a current attorney and former park ranger on the SPLAT team in 79. He got an affidavit from her in connection with his motion to dismiss. That's an interesting case. There's about five or six pending prosecutions of base jumpers right now that have just been sitting on the judge's desk in the Eastern District of California related to Yosemite, because David Nunn's lawyer has asserted essentially the same arguments that we have asserted or are going to assert in our appeal. And I think that my sense is that they're still trying to figure out what to do with them, so they're just buying themselves time and letting these sit. But I know it's making them nervous. Briefly, the sport was allowed in the park. In 1980, the USPA sort of flirted with the idea that they would regulate base as an offshoot of skydiving, right? So USPA under Director Joe Sivek spent a lot of member resources negotiating a permitted jumping program with Yosemite's then administrator, Robert Binawise. And they made a permit system almost exactly like the hang gliding permit system exists today, right? Amongst other things, jumpers had to submit a written application to jump. They had to have a D license. They had to limit their jumps to, 7 a.m., 7:30 a.m. to 10:30 a.m., only on certain days of the week, refrain from, like crew dog work, only use ram air canopies, so on and so forth, right? And they already hated the jumpers at this point, right? I mean, as early as 79, the SPLAT team was around, dangerously interacting, even trying to catch people as they were exiting, right? So endangering both ranger and jumper. But in 1980, they gave us our shot, and they set it up in a way that they knew we would fail. And if we get a chance to do this again, they're going to do the same thing, which is why compliance is so key here. They limited the number of permits to 12 a day, right? Well, this is all back when, information traveled a lot slower across the world, right? Everyone had just seen Carl's films and they said, holy shit, I got to go try this. And they spent thousands of dollars, by the dozens, by the hundreds even, traveling to Yosemite from Norway, from the rest of Europe, from, Maine, Florida, you name it, only to show up and they're out of permits. And what's a base jumper going to do, right? Famously, a bunch of them got arrested for jumping without a permit or for littering, for bolting rocks to, improve, make Lauterbrunnen style exit ramps and stuff like that. And 10 of them famously got caught on a flatbed truck. They were branded by the USPA as the flatbed 10 and drove up, a closed wilderness road to avoid the hike up and avoid detection and stuff. And that was sort of the straw that broke the camel's back. This was supposed to be a 3-month pilot program from August 1st in 1980 to October 31st, 1980, and we didn't last 5 weeks before they shut it down. And people were standoffish with them. They were rude with them. I mean, we've done our own part to get where we are today with respect to how the NPS treats us, is I guess what I'm saying. So
yeah, I guess that brings us back to the idea that the culture has changed, and what sort of control we could put in place if the permit process were to come back, right? Like, you don't want guys who buy, a rig off eBay and have no training going for it. Who would be behind the idea of granting the permits? You need to have some sort of advisor, right, to see who's qualified for a permit, or is that not even the question?
Maybe it's been floated, right? But, again, we're categorically ungovernable as a group, right? We've never had, a self-governing body like USPA. We sort of, a lot of folks typically reject that notion. We can't even really quantify how many jumpers there are in the world. Estimates by gear manufacturers, from 10 years ago suggested there were maybe about 10,000 active jumpers around the world, but nobody really knows, right? So the question of who's going to be the gatekeeper is really thorny, and we've talked about it. I think it's widely regarded as unworkable. I think, I don't have the silver bullet here, Laurent. That's a great question. But we have to self-police, at least within the parks. And I think that we've achieved a level of maturity as a sport, right? To appreciate what we lost 44 years ago, and to grab your buddy who's thinking about going at dusk without a permit to, Half Dome and say, hey, dude, please don't fuck this up for me and your other brothers and sisters and your children, just don't do it. And that's going to be tough. I mean, there's going to be people who disrespect that, right?
Right. I'm wondering if there's a time period that you feel is the most sensitive. If you were to say to me, hey, don't ever do this, I'm going to be like, yeah, nod and just kind of do whatever I want. But if you say look, right, we have, an objective within the next 5 years to put this in motion, is there a sort of time, workspace that you guys need to make this happen?
Well, I mean, the first years are going to be the most crucial, right? I mean, this ship is going to turn like the Titanic. It's going to take time to win hearts and minds. It's hard to sort of divine that without a crystal ball, what the specific need is. But I'm not sure you might also be asking about, what do we anticipate the timeline being for getting to an opportunity to get to a permitting system from where we are now? Is that sort
Sure.
of what you're getting at?
Yes. I'm looking for some optimism.
Sure. I don't mean to be Father Gloom here. No, so whether this is accomplished in a litigation process or by lobbying of appropriate policymakers and won over by engagement, it's going to take a couple of years. litigation moves like molasses. In the best case scenario, if we filed this year, we might get to a mediation and a possible summary judgment, an opportunity to win before trial no earlier than, a year from then. And then the reward for doing so, even if we do win, is that we're going to have to participate in a planning process, right? I think that's kind of a reality that we're all sort of groaning about. It's not fair necessarily, right? Certain sports have just been grandfathered in because they were always around. Things like climbing, that never went through a park planning process. They allow it anyways. They allow even new things that have come up since planning was required, like slacklining, which has a big environmental impact, without a planning process because the Park Service views that as sort of climbing adjacent. And so, but we're likely to have to do a planning process, which is fine. I am confident, and everyone who's looked at this is confident, that if we just got the opportunity to do so, they're going to find that it's a perfectly appropriate activity for the park. It's not going to impact the golfers or the bariatric tourists on the fucking, bus, or the people in the lodge, or the bird watchers, it's got a lower environmental footprint than the other aerial sports allowed there right now. And in fact, the sport was fucking born there. Yosemite is like the crown jewel of base jumping in the United States. And all of the ones that follow after that also sit in national park units, right? Your Zions, your Northern Cascades, so on and so forth. But it just needs time. That's all. Time and positive engagement with these folks, right? The people who work at the Park Service care about their duty to preserve it unimpaired for future generations. They care about the user experience. They need to just be educated and shown that we're partners. We're not enemies, as we've historically cast ourselves, like in this cat and mouse game. And that takes engagement, that takes cooperation, it takes compliance with rules and patience with planning processes, right? We just need to get our chance to get into a planning process because what their strategy clearly has been, successfully I might add, for the last 50 years, is to just say, we'll get around to it, whenever we have the resources, So that's the objective here.
You're a busy man. You have a family. You have a job. You have your own activities. What is it about this pursuit that is continuing to bring you back, and what keeps you motivated?
Man, I don't get to do much of anything anymore, right? I'm lucky if I can hop on my mountain bike or like go throw some weights around in the gym an hour 3 times a week, right? I think I did 3 jumps last year, one of which was in Lauterbrunn when I was getting married. But what, this is cliche, right? But what brings me back primarily is the community, right? Middle-aged people have a notorious, sort of peer-reviewed struggle with maintaining a social network outside of their families, right? We get busy, we get the mortgage, we get the job, we get the kids. They fucking need something every 3 seconds.
I'm nodding in agreement.
They're cute, but but what's cool about this is the community. You can get on a Web 1.0 page. I mean, I met my good friend Lane Coates, may he rest in peace, on basejumper.com, like old school style, in 2019. My then girlfriend and I were in Houston visiting her parents. Said, like, anyone up? Like, what's up? And, like so many jumpers, you show up in a strange town with a rig on your back. You got a warm bed, a hot meal, a cold beer, and a best friend for life. And you like many other friends that I've met, took me around, and we, did some objects probably can't talk about, and kept in touch, for the rest is history. And that's really difficult for adults to do. And the fabric of this community is super cool. So that's number one. And then number two, it's like, did you ever want to be like a fighter pilot or anything when you were a kid? You sort of grew up in the Cold War era too, right?
I always knew that was sort of out of my grasp. But everything just felt otherworldly. And, my, I think, approach was a little bit different. Like it just seemed like otherworldly. And then as I matured a little bit, I gained the confidence to say, like, you know what, I can do this too. And so it was a little bit different for me, I think. But now I get to fly my own personal fighter pilots. Rich Webb would probably call us the dodo bird of fighter pilots. But man, the sensations are there; they're real.
It's got to be the purest expression of flight known to mankind. I mean, there's just nothing like it. Not even jumping the wingsuit out of the airplane. I mean, you're in nature, which is already just awesome, in these stunning surroundings with your best friends, and you get to zip up a fucking fighter jet and fly like Da Vinci could only dream. And like you said, I mean, there's no feeling like it, right? It's like a drug. Really quite, I mean, that's maybe a negative way of putting it, but I just can't describe it. You know what I mean?
It leaves you with amazing sensations. That's for sure. Before we go, and I have you, I feel like we need to cover how to act if, in case we have broken the law or we're in a gray area, and how to speak with the police or the Park Service Rangers or whatever law enforcement entity is there. Because a lot of times it seems like, as you did as an 18-year-old kid, you gave up the goods. You ratted on yourself. And maybe we can help some people to, have the right things, the right understanding of their rights, and do the right thing when they get into that bind. Do you have any advice for people who are in that gray zone, perhaps, and are faced with dealing with the law?
Sure. So I have only done one criminal case ever, and that is one of my favorite base stories that I'll talk to you about over beers sometime, because I can't talk about it here. But representing, 5 friends who were apprehended at a multi-day bandit boogie at a large object somewhere in the United States, one statute of limitations ago. I'll leave it to you to decide if I was a participant or not, right? The fundamentals, though, are, if you are engaged by a law enforcement officer, certainly ask if you're being detained, right? I would not run from them. The easiest way in the United States to get thrown on the ground and jailed, or worse, shot in the back, and the officer gets off the hook, is resisting, right? Resisting arrest. So once you're engaged with law enforcement, you need to be respectful to them, right? You do not talk to them. Talk about the weather or whatever, but you don't have to answer any questions without counsel present. Just physically cooperate. And that begins with asking, am I being detained, right? Because if the answer is no, then you're free to go. And then you say, have a nice day, sir, and move on. If you are, you ask the officer, they all have lapel cameras now. So, what you're working towards is setting yourself up to get this resolved in court later, right? You're not going to clean this up on the spot. And that's one thing I want to impress upon everyone, no matter what a police officer or law enforcement officer tells you. You're not going to have a conversation with them and just fess up to some things and walk away, right? I think my story is a great illustration of that. But you don't have to talk to them. Ask if I'm being detained. Yes, you are. Do you have a reasonable, articulable suspicion that I've committed a crime, officer? That's the standard for an arrest, right? Reasonable. You have to be able to say what you're arresting me for, which is a low bar to clear. But sometimes people can't even articulate that. And then later on, when they arrest you anyways, and they're going to, and you're going to physically cooperate because you don't want to get shot or, have an extra charge thrown at you for, assault on an officer or resisting or, whatever. If they can't articulate that, then you're pretty much done later on. And then you keep your mouth shut, right? You don't incriminate yourself. If you are being detained, there's a 1976 Supreme Court case called Terry versus Ohio that established that, because, you're being physically detained by a police officer, you sort of, they don't know you from Peter or Paul. They don't know if you've got a knife or a gun or whatever. So they're going to be allowed to pat you down, to search you for threats, to satisfy themselves that if they stick you in the back of the car, you're not going to slit their neck, right? And oftentimes, Terry searches result in them finding, let's say you got a jumper out there in a jurisdiction where marijuana isn't allowed, and, they got a bag of weed in their pocket or something, right? Something else that is unlawful to possess, but isn't a weapon and is not connected with the alleged crime of, trespassing or base jumping, whatever the violation is that they stopped you for in the first place. Again, you're not going to talk to them about it. You let your lawyer work that out, right? If they find something other than a weapon, the search is supposed to only satisfy them that you're unarmed. So anything else that they find that they try to use against you to enhance your charges is sort of, it's the product of an illegal search at that point. It's called fruit of the poisonous tree. And your lawyer will go into court and file a Fourth Amendment, motion to suppress that evidence and perhaps dismiss that charge, right? So don't get flustered. Their job is to fluster you and to back you into confessions and, all that kind of stuff. Again, like, you're going to cruise on such easy street if you are just respectful, keep your mouth shut, physically cooperate, let your lawyer do the work.
So it sounds pretty easy. It's like you said, don't talk to them about anything that you are suspected of, and then let your lawyer do the work.
Yeah, that's right. I mean,
Be
if they want
polite,
to arrest you, they're going to arrest you. Right.
Okay. That's some good advice. Is there anything else that you'd like to talk about?
We've covered a lot of stuff today. I just, I hate to beat on a dead horse, but I just, I'm proud of this community and where it has gotten to from, its wild roots. I'm excited for where it's going, and I'm proud that the participants that I know in base are all conservation minded, leave no trace, conscientious, all of those kinds of things, right? Like, we're just like fucking John Muir or anyone else who appreciates the parks nowadays, right? Even though the NPS still views us as a circuit stunt based on, interactions with 10 people 44 years ago, we can change that. And it's not going to be easy. And, at first they're going to treat you like suspiciously, but this is won by engaging and being responsible. So do whatever you want outside of the national parks, right? I mean, to a certain extent, base necessitates some legal gray areas from time to time, right? And that's your own business, and that's the game we play. But if we want the crown jewels back, and we want to go far, follow Carl Banish's and Paul Smith's footsteps and get that big mountain air and soar with the eagles, you gotta be nice back, even when they're not being nice to you, and you gotta follow the rules. I mean, I sound like my dad now, so I guess I'll sign off with that.
That's a great place to end it. Kendrick, we're all super happy that you're behind this and you're working hard to unlock those crown jewels. And I'm hoping that we can have another conversation like this in the near future where you can share a bunch of good news with us. But for then, thanks so much for sharing your expertise.
Thank you. Yeah, I'm looking forward to it. Hopefully we'll have some stuff, in the coming months, and looking forward to getting to know you a little bit better too, man.
Yeah,
Thanks for having me.
You're going to have to come have that beer with me, like you said, share that story.
Yeah, don't threaten me with a good time. I'll be back in Europe.
Cheers.
We hope you enjoyed this episode. If you have any thoughts about what you've just heard, please don't hesitate to hit us up. A big shout out to Mark Stockwell, our sound mixer and co-producer. We love you, man. If you'd like to learn more about the podcast, please visit exitpointpodcast.com. See you on the next one.